Now, you have to remember, I'm not just an academic, I'm a barrister. I litigate cases in the English courts, I litigate cases in the international courts. I cross-examine, I look at evidence, I'm interested in documents. I read these documents very, very carefully, perhaps essentially with the eye of a barrister. And there was something that struck me as being problematic about the narrative that was being spun by the administration. Because when I read for the first time the transcript of the press conference given by Mr. Haynes and Mr. Gonzalez, it struck me that they were actually acting as advocates, that they were speaking to a common and very carefully prepared script, which articulated a particular narrative and a set of messages, including the 4 points that I've just described. So I thought what I'd do would be to try to track down and meet each of the individuals who had been described and had been involved in the decision-making processes. And starting from London, I can tell you that was not an easy task. But what I wanted to do was to establish, not on the basis of the documents, but on the basis of what the people who'd been actually involved said had actually happened. Not just believe what the administration was seeking to have us believe had happened. Over a period of time, I did indeed speak with almost all of the key players involved in the decision-making process, right up to the very top. And indeed, I think it's a testament to the nature of modern American society that an outsider like me can cold call someone like General Myers, Chairman of the Joint Chiefs of Staff, and ask him to have a conversation with me. Or meet with Doug Feith, who was the number 3 at the Pentagon, or track down Diane Beaver, the Guantanamo Bay lawyer, who was one of the first individuals that I actually spoke with. Or, eventually, as happened with some pushing, be invited to the Pentagon, not once but twice, to spend several hours with Jim Haynes himself. There is a wonderful, wonderful openness in American society. This would never have been permitted to happen in Britain. One of the first people I met with was Doug Feith. Mr. Feith is a lawyer, and he's probably better known for his role in promoting the 2003 Iraq War. Yet, it turned out he was rather deeply involved in the decision-making processes that led to the Rumsfeld memo, although the memoir he published in 2008 is surprisingly discreet on the subject. In fact, it doesn't mention his involvement at all. I talked to him about the circumstances in which the Geneva Conventions had in effect been set aside. That, as you know, had happened as early as February 2002, and it created the legal black hole into which all these characters were cast. From him, I wanted to understand what had really motivated that decision. Mr. Feith's a lawyer, and he affects something of a lawyerly approach to these matters. On his account, he proceeded on the basis that advice had indeed come from other lawyers in the Department of Justice, contrary to what the narrative was being spun by the administration, and in the Department of Defense. But what I managed to elicit from him, which in my mind was the most significant thing, was that the decision to do away with Geneva, as early as February 2002, was precisely intended to remove constraints on interrogations. In other words, as I understood it, this decision reflected a pre-existing policy decision as early as February 2002 to move to abusive interrogation, and that it was a decision taken by the upper echelons of the administration itself at the political level. I also picked up from Mr. Feith something as to the connections between the Rumsfeld memo and the Hugh-Bybee memo of the 1st of August 2002, at least the role of the lawyers in the Department of Justice, in authorizing, behind the scenes, those techniques of interrogation. That was a significant interview for me because it confirmed what many instinctively believed, but what the administration had constantly denied, namely that there was a relationship between the desire to remove constraints on interrogation on the one hand and the effectiveness of the Geneva Conventions on the other. And around the time that I first met with Doug Feith, I also spoke and met with Diane Beaver. She was the staff judge advocate at Guantanamo Bay from June 2002. She went to Guantanamo Bay at about the same time it was discovered that detainee 063, Mohammed al-Qahtani, might be the 20th September the 11th hijacker. He'd sought entry to the US in August 2001, shortly before the attacks of September the 11th, but that had been denied and he was removed from the United States. He was then caught a few months later in November 2001 in Afghanistan and eventually transported to Guantanamo Bay at the end of January 2002. 6 months later, in June 2002, the dots were all joined up. he was discovered to be, apparently, the same man who had gained entry to the airport in Orlando in August 2001, allegedly at the very moment that one Mohammed Atta was seen on video camera waiting in the arrivals lounge for someone to arrive.